Good afternoon. Director Keenan did say that I'm a lawyer. I was a police officer before I went to law school, so let's put that out there. Started out at Emory University Police Department, then Jacksonville, North Carolina, and then came to GBI after I'd been practicing law for a few years. We did put together a policy. I will give a shout out if anyone's here from New York Police Department. They actually had the first policy governing the use of social media in investigations. And ours at GBI was the second. We were doing the work on the privacy committee with CICC. And the entire text of our policy is available as an appendix to this document, which is referenced in the PowerPoint. It's available online. And I'll hit the high points on the policy and kind of tie that together with what Director Keenan was talking about in terms of reigning in the Wild West. As Nancy pointed out, 58% of the agencies who participated in the survey are using some sort of undercover online profile. That's a great number, and 80% of the agencies that responded to the survey reported that the use of social media enabled them to solve crimes. So it's a wonderful tool. This policy, the purpose of this policy is not to tie anyone's hands. As Director Keenan said, there's not a lot of law in this area. There will be law that's made, and we're hoping that with wise policies and officers who are prepared to testify that, yes, this is what I did in accordance with this authorization with the agency, and I kept track of what I did in my criminal case file, and this is the online undercover identity I used, and so on. The courts will say, yes, this is a very rational, wise, investigative tool, just like the court said back in the early 70s that we could go undercover, assume undercover personas in investigating drug cases. And obviously the child exploitation, the internet crimes against children is the area where we're doing the most work online with undercover activities. The purpose of our directive, the policy that we created, is to establish the guidelines for the use of social media in 4 areas. The pre-employment background investigations, and I'll talk briefly about that. Crime analysis and situational assessments, that may be your fusion centers or your intelligence units or your units that are dealing with issues related to First Amendment protected demonstrations, criminal intelligence development, and criminal investigations. Always, per our policy, there must be a valid law enforcement purpose. That's what we expect when officers are on duty, that our employees will be using social media and the social media websites and the monitoring tools only for a valid law enforcement purpose. Just like if we go to the sieges, the NCI use, if you're familiar with that, regrettably, there are officers who access it for inappropriate reasons, for personal reasons. They see an attractive woman driving a car, so they run her tag. That's not an authorized law enforcement purpose. Similarly, we would not expect someone to be using the social media accounts or their undercover online activity for personal reasons. So this just kind of puts that in the frame. That's the overarching frame within which our policy governs the use. We, again, set forth the times when it's authorized to use social media, and we also set forth the times when it's not authorized. This, I tried to craft this as broadly as possible, and I think those of you in the room with English backgrounds and very analytical types will say, wow, there's some overlap here. Yes, there definitely is, but the thought was I wanted to make sure that we covered the broad sphere of all the law enforcement activities or criminal justice purposes that our employees might be using social media for. So again, based upon the function of your agency, you may want to narrow some of this. Obviously, criminal predicate or threat to public safety, criminal intelligence information, and the policy utilizes the definition, the 28 CFR definition of reasonable suspicion. And then this one, relevant to the investigation and prosecution of suspected criminal incidents. We've got that. That's pretty clear. That's what we're doing in law enforcement. But what about if someone calls you and says there's something going on with someone who's incarcerated in prison? The enforcement of sanctions, orders, or sentences, or the prevention of crime. So keep in mind the whole ambit of criminal justice response. We can use that. and also the situational assessment reports, we talked about that a bit, and then relevant to pre-employment background investigations. Now, we have a very narrow use for pre-employment background investigations. As Nancy mentioned, there are a number of states that have passed laws prohibiting employers, whether they're law enforcement, criminal justice employers, or whether they are private employers, from requiring individuals to turn over their passwords to a social media account, for example, Facebook. That's kind of rational because when we've done background investigations in the past for positions of trust, we've never gone and asked someone to turn over their diary, nor have we ever said, well, we need to search your house and review your papers that you've written. So this is, I think, from a public policy perspective, the recognition on the part of the legislators that this is too much information, that employers should not have the right to require the applicant to divulge their passwords. We recognize that. We do say in our consent form for our pre-employment backgrounds for law enforcement positions or the position of trust background checks that we do for the governor's office. We do say that we will review social media information that's available to the public. So if their Facebook account, of course, is private, then we would not see that. But we've limited there, and you'll see as I move through the different policy provisions how we don't use an online undercover alias, nor would we use online undercover activity when we're doing a pre-employment background check. We will not use social